All right, so this is what the court is going to do. Number one, I am not going to grant the motion to dismiss for want of speedy trial. Number two, with regards to exclusion of evidence, if there is any exclusion of evidence based on.
If you recall, Judge, from the last setting, we were set for trial. We were set for a motion to suppress evidence. About 20 minutes before that motion to suppress evidence, I was given some records pertaining directly to that motion to suppress evidence. And after that, obviously, I was forced into a position where I needed to request more time to review those records to see what that was about prior to the hearing.
Yes.
And you granted a continuance. I didn't want to have to ask for that, but I was forced to in order to effectively represent my client.
If I remember correctly, I stated that neither party will be charged a motion for continuance because if I remember correctly, and I'd like to think my mind is still a steel trap, although people have been trying to gaslight me of late. But what I remember is that the state had obtained some information, and it wasn't information that it just had sitting in a file somewhere. And so it didn't seem that it was neglect on the state's part or lack of diligence on the state's part. And I know you needed more time to review. And so the court said, I'm not charging anyone with a continuance.
The only small part about that I would disagree with, Judge, is that the San Antonio Police Department is part of the state, and they've had those records since for years. I'm not saying that this prosecutor had those records, but the San Antonio Police Department sat on those records until they were forced into this motion to suppress. And at the time, and the state had also filed their own motion for a continuance based on the unavailability of a witness.
Okay.
And now, and you admonished the parties, Judge, at the last setting there was going to be no more continuances. This was going to be set for trial at the end of March.
Yes.
Since then, in the last 10 to 20 days before trial, we have received a tremendous amount of evidence, Judge, that's been uploaded. There's been 212 jail calls, 44 new videos, body cams, dash cams, 53 new PDF documents. And of those documents, one of them is a 571-page gunshot residue detailed lab report of the opinions set forth in the previous gunshot residue lab report. There was a Brady notice for the gunshot residue in the Bexar County Crime Lab. The letter was written from the DA's office in December of 2024. There was punishment evidence that was uploaded, all of cases that have been in the state's possession since before even this alleged offense date, as they are older files. There was a new firearms testing report that was requested by the state on the same date as the last hearing. So on February 20th, there's a submission saying that the state requested further firearms testing.
So I understand where this is going, but what are you going to be asking for?
I'm going to be asking for you to dismiss this case, Judge, based on a violation of my client's speedy trial rights. Okay. And if you let me just hash all that
on the record.
And so that evidence for that motion to suppress hearing on February 20th, that was in the San Antonio Police Department's possession since I believe the date of the offense, which is May 22nd, 2022, because it was real-time cell site location information, cell phone tracking data that was to Mr. Ashbaugh's cell phone. And so they requested that through his cell phone provider, and they had possession of that since the date of the offense, which at this point has been almost 3 years. And at the last setting, Judge, you gave me time to review that, and you admonished the parties that there would be no further continuances and that we would be proceeding the trial at the end of this month, March. However, in the month of March and in the last 10 to 20 days, I believe, I've received a tremendous amount of new discovery. And as I stated, that was 212 jail calls.
I'm sorry, counsel, sorry to interrupt. So, so that I can take proper notes. Now, the items that were given to you on February 20th, what were those items?
So February 20th was just the real-time cell site location data which related to the pings of Mr. Ashfall's cell phone and license plate reader information.
All right. And how long are you saying that the police department had that evidence?
Since the date of the offense, May 22nd, 2022.
Judge, and I do have a response to that, but do you want me to wait until?
No, we'll just take everything one step at a time. So we'll start with that. So the real-time cell site data, defense, you're saying that the police department or the agency had access to that, we'll say, since May 22nd, 2022.
Yes.
And then you received it from the state on February 20th, 2025. All right, so let's start there. State, you want to address that one issue?
Yes, Judge. So regarding that cell site location data and the license plate information, that was tendered to Mr. Navy at the last setting. It is my understanding that although a detective with SAPD did receive it on the date of the offense, which is May 22nd of 2022, SAPD was not in possession of it because that detective was no longer employed with SAPD. And so once I learned of the existence of this record, I actually had to call up to the chief's office, and they were reporting to me that they weren't going to be able to retrieve it because that officer was no longer with SAPD. However, I told them that they needed to get with their IT department to get into the officer's drive to try to obtain it, but it was not. I went to look at the case file. It was not anywhere within the case file. And so ultimately, after conferring with the chief's office, they were able to retrieve it from the ether somewhere and provide it to me. As soon as I learned of that, I called Mr. Navy personally and let him know that they should be sending it to me. And then when I received it, I immediately gave it to him.
So you're saying that that first item with the real-time cell site data, that an officer retired or left the occupation and nobody had access to his data?
So that's my understanding, Judge, that it was not properly preserved, and so nobody had because it was not within the case file.
In the month of March 2025, I've received a vast amount of evidence that has been previously undisclosed to me.
All right, so let's do this because I say take the easiest part first.
Right.
So one of that is jail calls.
Yes.
All right, so let's talk about the jail calls. And I'm assuming the jail calls, are these alleged to be your client's jail calls?
They are.
All right, so let's talk about jail calls.
Okay, so there's 212 jail calls by my count. That number may be off by a couple if I miscounted, but more or less 212 jail calls. Those jail calls are from the day he was arrested, which was also May 22nd, 2022, until I believe somewhere in June. But my client didn't bond out until July 14th of 2022. So I don't even know if these are the complete list of jail calls because they end at a certain date in June. But still, it's a vast number of jail calls that I would need to sort through. The state's provided. That means I assume I don't know what they may intend to use off of there. If there's anything exculpatory, anything that's not good for my client, but I would need to review those.
All right, so state, with regards to the jail calls, because it appears based upon what defense counsel has stated, that his client was released from the jail in the year of 2022.
Yes, Judge. So the calls that were retained under this defendant's SID number were from his date of arrest, his date of release. That would be May 22nd of 2022 to July 13th, 2022. And these calls had not been pulled by any other prosecutor, and they were uploaded to e-discovery on March 3rd, 2025.
All right, so what I can tell you all with regards to the jail calls, I understand that sometimes when someone's in custody, if they keep making calls on a daily basis, then you're going to receive some phone calls, well, jail calls that are given to you not immediately because they're continuing to make calls. But in this instance, what the court is going to do with regards to his jail calls is that's going to be excluded.
Well, Judge, right now I'm not asking for exclusion because, and I'm hesitant to do so, because there may be things that that corroborate the defense in those jail calls, Judge. And so it's basically, and the gist of my argument is the state has placed me in a position between a bad decision and a worse decision.
Well,
Right.
this is what I can tell you. With regards to your real-time, the cell site data location,
At this point, the evidence issue is becoming much more complicated. The court has already addressed a major portion of the jail call material, but the defense is still pointing to the sheer volume of information that arrived during the case. And that raises an important question. How much time does a defendant realistically need to review everything before trial?
Okay. And then 53 new PDF documents. And of those, I've identified that those include a 571-page gunshot residue report, punishment evidence of at least 4 cases that are older than this case itself. So 4 cases that the state has had in its possession since before May 22nd of 2022. Gunshot residue Brady notice that the DA's office has had because their letter is dated in December of 2024. New firearms testing that was requested by the state on the date of the last suppression hearing. So they requested firearms retesting on February 20th of 2025. And then a new firearms report was issued in March of 2025. So probably just a few weeks later. And so I have a new firearms report. Also have new cell site location reports, not real-time cell site location, but historical cell site location. And then case overview reports pertaining to this case. So those 2 items, those reports are dated 2022. Officers wrote those in 22, and those have not been available to me until this time. I submitted my request for discovery and was very thorough in all the different types of evidence that I was included in. All these are covered by that motion, as well as punishment evidence, which I requested on that date on June 6th of 2022. So that's over 1,000 days ago. I've requested all of this evidence, and much of it has been in the state's possession for years. Now, whether it's one ADA who didn't look at it or another one, that doesn't matter to my client. The effect is we were ready to go to trial on the evidence that we had at the last setting, and then it was reset. We got ready again to go to trial on the evidence we had for this setting, and then it turns out that there's a whole swath of new evidence. And I will tell you, Judge, that one thing I appreciate about this court is we have a lot of discovery compliance dates at first, and you make sure that all the discovery has been complete. And then once you ensure that that's been done, then you set it for a plea deadline setting. And then after that, you give so after the client's had some time to determine whether he wants to accept a plea or reject a plea, then it proceeds to jury trial. I should be spending this time before the jury trial, preparing for the jury trial, not reviewing new evidence. And so it's undeniable at this point that Mr. Ashbaugh has made decisions on first-degree felonies, of which, if he goes to trial and loses, could potentially be spending the rest of his life in prison. He has made decisions now without knowing all the evidence that the state was going to use against him. And so at this point, Judge, there has been a violation of his speedy trial right because the prejudice to him has been so great.
Now the defense is shifting from simply identifying late evidence to explaining its actual impact. The argument is that receiving information late can affect more than preparation. It can influence strategy, investigation, and the decisions made before trial. But the judge still has to determine whether that delay legally justifies the extraordinary remedy the defense is requesting.
all right, so this is what the court is going to do. Number 1, I am not going to grant the motion to dismiss for want of speedy trial. Number 2, with regards to exclusion of evidence, if there is any exclusion of evidence based upon what the court heard, what will be excluded will be the jail calls and any punishment evidence. But the court is not excluding that at this point because defense, you're saying you don't know if you want it excluded or not. So defense, if after reviewing everything, you decide you want the jail calls excluded, then the jail calls will be excluded. After reviewing everything, if you decide that you want the punishment evidence that was, and when I say punishment evidence state, I mean that was recently turned over. If you decide that you want that excluded, then it will be excluded. And when I say punishment evidence, the court will need more knowledge to make a determination.
After nearly 3 years of restrictions and repeated delays, the defense is asking the court to look beyond individual pieces of evidence and consider the overall impact on the case. But proving prejudice is one thing. Proving that the prejudice is serious enough to justify dismissal is another, and that distinction is about to become critical.
Thanks for watching and subscribe my channel.